Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper. Thank you for tuning in and enjoy this second part of our interview with Bobby Shukla. In today's era where everything is digitized and where people know what is right and what is wrong, how is it possible that this kind of behavior still goes forward without people recognizing that there are going to be consequences? And the reason I'm worried about sounding naive is because I'm guessing what I might hear from you is that because in a lot of situations there are not consequences.
Yeah, I think that's right. And you know, it's also it's not a naive question. It's a real question, and some of it is unanswerable because it's something about the human condition, the human brain. I mean, this was Bay Area. This is a public entity within one of the most diverse counties in the country, right? I mean, it has to be up there, Alameda County. I think the leanings were progressive, you know, compared to other parts of the country and within it. And I think what it is these forces are so powerful that even when you think you are not, you know, acting in certain ways that are favoring one group over the other, I think it's two things. It's the inability to admit, right? So when it's brought to your attention, people just double down and get entrenched because they can't accept that what they're doing is actually motivated by a race bias.
So let me ask you a question on that. It's a general question, not specific to this case. Do you get the sense that this is a subconscious? I know there are bad actors, like malevolent, creepy, overtly sexist, overtly racist individuals.
Yes.
And my question that I'm slow to get to is, do you see that type of behavior, or is it more what I would call subconscious bias? Like, I don't think of myself as being a racist, and I have a hard time with people who are not sophisticated. Oh, air quotes.
Right. What does sophisticated look like, right? And obviously nothing about, it goes without saying, nothing about her was not sophisticated on her resume, on how she spoke, on, you know. But what's really interesting is what you're saying, and maybe it's more interesting because I'm an employment lawyer and maybe it's not as interesting otherwise, but it's that we have to prove intentional discrimination. And so this idea, so there is, like, this is developing in employment law, like how does unconscious bias play into proving intent to discriminate? And in this case in particular, which was interesting, they commissioned 4 independent investigations. This always happens in employment law, right? Oh, we're going to do an investigation. There's no finding of wrongdoing. So we did our due diligence, we acted promptly, and there's no finding. And they tried to lean on those in trial very heavily, thousands of pages with evidence of this is how we can establish they did nothing wrong. But one of the investigators had found that the general counsel acted with quote unquote unconscious racial bias against the African American employee, which is kind of huge and weird because she's admitting disparate treatment between the white comparator who he had hired and her. You know, what is really the difference at a certain point? Because how can she know what he's doing consciously or subconsciously? You can only know by the actions. So the most important part about that finding for the trial and proving, attempting to prove the case is that they took no action. So there's this finding that he acted with unconscious racial bias. How does someone even come to that finding? But then, that was a way for the investigator to say no policy violation because it was quote unquote unconscious, but they still took no remedial action. If this person is acting in unconscious ways that discriminates against African Americans, there needs to be something done about how he operates. Training, nothing was done.
I want to go back to the proving intent, however, because a concern I have is as people get more conscious about their racism and their sexism. So I think of myself as an enlightened being. And I'm smiling as I say this. And I'm smiling as I say this because while I've done a lot of work and I've surrounded myself with people who I think of as being fair, equitable, what have you, I also know that there are certain things that I do that are racist, sexist, are based on my privilege.
Right.
When it gets brought to my attention, I am revulsed by.
Right.
And I don't know that I would ever feel that I'm intentionally being racist or sexist.
Right.
And I know that some of my background can drive behavior that is that way.
Right.
So how do you as an employment lawyer help a client who is negatively impacted by somebody like me?
Well, I think here's the difference. And you've actually articulated it really well with this kind of developing thing in employment law, because there's this huge consciousness now about and it's funny I'm using that word, right? There's this consciousness about unconscious bias, and it's, they're training the judges, and which is great.
And I'll use a different phrase, but kind of I think of it in the same institutional racism, where it's not an intent now,
right?
But it's built on past intents.
And privilege, and everybody has levels of privilege. You might have white male privilege. I have all kinds of privilege as well. So like it's resonating with me too that I, do things that are racist and sexist. And, kind of going back, just to be off course a little bit, the disadvantages and advantages I have in a courtroom, one of the things is this whole kind of model minority concept where I know I have tremendous advantages compared to African American lawyers and Latinx lawyers, because of the perceptions. Because often the stereotype of a lot of Indian Americans, because we've immigrated from far away, so you're getting a certain group that's coming. The immigrants who are near the border, you get, people of all socioeconomic backgrounds. Immigrants from faraway places typically have privilege to get here. And so a lot of, the associations that people have with Indian Americans might be that it's your doctor, or whatever. So I'm getting that kind of advantage, even though I'm a woman of color with dark skin who might not look like a lawyer, but I might be a safe look in other ways that an African-American lawyer, because of racist perceptions that are built on 400 years of this country's history, doesn't get out the gate, And Black men, there's different stereotypes around Black men than Black women, all of that. So I digress, but going back to what you were saying, I think what you're describing isn't the typical bad actor in an employment case, because the key is if someone acts in a way that, like in this instance, there was many things this person did that actually is a bad actor type thing. It wasn't subtle, unconscious stuff. This is just how it was characterized to protect them. And I won't go into all the details, but very overt things as well, though no epithets, right? But the difference is if you did something like that in a workplace and then there was an awareness about it and then there was remedial action, that's not a lawsuit, because people are going to act in ways that are informed by privilege subconsciously. And what I learned some time ago is to question your assumptions. That's how you get around unconscious bias. So you're not going to get rid of it automatically, but the way you train yourself out of it is, if I'm walking down a dark alley and I see Miles Cooper and I see a guy with kind of a goatee and what stereotypes about you are firing? Is this guy going to grab my wallet? Is it,
probably on a Harley with a crowbar, and he's going to come after me.
Right.
Yeah.
Is he going to break the window there? And so stop and question your assumptions. Why am I thinking this about this person?
Yeah.
Right? Is it because of his skin, his race? And is there any other marker that really leads me to believe that he's going to cause any harm? And so that is a separate thing from most of my cases. That what I'm trying to say is that is not the picture of the bad actor in an employment case.
What is, and again, I'm asking a stereotypical question, but from a stereotypical perspective, is there kind of an archetype nemesis generally in cases that come across your desk?
Yes, but kind of in the subcategories. So in sexual harassment cases, the archetype is a sexual predator. that would be the same in sexual assault cases in the non-employment context, right? Someone who knows how to find their victim, so to speak. And sadly, it's often someone who's been victimized in some way before. And predators know that about people. And, arrogance and power complex, all of those stereotypes would apply there. In other cases, it's often, I would say arrogance is a running characteristic often for the bad actor, but it's the scenario that is like almost every time is new boss. So you have a long-term employee, things been going great, they've been doing well, and then a new boss comes in, and then you're getting a call from a person. It's like so often the fact that changes why there's an issue. And so, it's usually that person imposing something like no longer wanting to accommodate that person's disability in the way that it's been accommodated for a long time. And so what is that personality trait? That's someone who has a power complex, a power trip.
I want to follow up on that because one of the things that I'm hoping people who listen to this are able to take from the conversation is, and I make a presumption that a lot of the people who listen are dealing more in the personal injury or other sphere. And they might be the lawyer in their family, or they get the cold call from, you help me out with this, but this is going on at my job. Can you help our listeners understand the difference between new boss coming in who is a bad actor and new boss who is coming in who just is a jerk?
Yeah. And that's a really good distinction because, people are very familiar with the phrase hostile work environment and use it all the time. And in intake, calls, people always like, I'm experiencing a hostile work environment. And it's a very prevalently used word, but equally misused in terms of the definition. And my joke is like, I'm a solo practitioner, and I also have a hostile work environment, but I don't have a lawsuit because it has a very specific definition under the law, and the law does not protect you if your boss is a jerk or an asshole. There's no protection for that. If your boss is a jerk or an asshole to you because of your race, gender, sexual orientation, gender identity, for something that the law has deemed should be protected, then you have a claim. The word bullying is used a lot lately, and for it to rise to a hostile work environment under the law is not necessarily common. Because basically, like for sexual harassment, and people don't understand it and say like, oh, if I ask someone out and they say no, I'll get sued or, something. And it's a pretty high standard. And people don't realize that. It's like you need something to be severe or pervasive. The less severe, the more pervasive it has to be to qualify as a hostile work environment. The more severe, the less frequent it has to be. So an act of touching is severe on a sexual body part. If it's comments, they have to happen on a frequent basis where it affects the person in a way that is both objectively reasonable. The reasonable woman or man in their shoes would feel that way, but also subjectively affected them. So there's, like anything in the law, you don't throw it out and it sticks. There's really a test, and that is much harder than people think to even get it to pass summary judgment.
One of the things that I hear a lot from employment lawyers is that there seems to be in employment a summary judgment motion pretty much every case.
Yes.
All of what you're talking about sounds like tribal issues of material fact.
Yeah, that's a good point.
Is a touch on the back for one person off-putting for another person, and it seems it's all contextual, it's all testimonial.
Yeah.
How can those issues be issues that are not tribal issues of material fact, be ones that a judge can take away from a jury?
The one type of case where it's less common to get a motion for summary judgment is sexual harassment. But you can get them if it's not frequent enough. So let's say you had one comment in 2 months, and it could be overtly sexual. But then another comment in 2 months later, and then you only have 3 comments in the course of 8 months, even if they're overtly sexual, does that qualify as a hostile work environment? It might not. It could be kicked on summary judgment.
And there's case law that
discuss, yes. There's cases that talk about, and there aren't like hard lines, but you cite cases, and they cite cases that talk about, can this qualify as a hostile work environment? And you have to try to liken your facts to the case or distinguish it from a bad case.
I guess the challenge I have, the person complained about back pain once, and then 2 months later they complained about the back pain, and then 2 months later, that's not sufficient really to be an injury bad enough for a car crash. I, as a judge, am going to take that away.
Yeah,
I mean, quite honestly, it seems like baloney.
I know it is, and but that's how. Because even in the case I keep going to, because we're just talking about it, that's the trial lawyer of the year one. We initially had race-based harassment as, because you plead everything, but it just didn't rise. We actually passed it on summary judgment. We had 22 causes of action, which is insane, and actually survived all of them on summary judgment. But then we didn't go with a trial because there wasn't enough things, even though it felt like that's what was happening.
So let's go down that avenue for however long we go. As you get to trial, how do you decide whether to kitchen the sink and hope for the best versus honing in on, this is my one point or my three causes of action, and within that same avenue, not end up with a verdict form that looks like a IRS tax return?
That's funny. I haven't heard that.
That was a Cynthia thing. Like, I want as few questions as possible. One question would be great.
One thing that's interesting that people don't know about sexual harassment, because I think when I was giving the example, it's like, how did that person subjectively feel sexually harassed? It doesn't have to be directed at them either. So if you're in an environment where your colleague is being sexually harassed and it affects you, you have a claim for sexual harassment. That's just a little point that people don't necessarily know. And then what I was going to ask you before I get to, because it's a really interesting question, how do you know what to go forward with? Does that happen as often in PI cases? Because it happens very often with employment. Like, you have disability, race, age, and like you could potentially have all of them. And what do you hone in on?
It does not happen very often in the injury world. Mm-hmm. The verdict form that caused great consternation in my life was when we did the spicy burger case, where there was primary assumption. And
you were nominated for trial lawyer of the year for that too. Yes,
we were the collective lawyers who did it. Yes. But back in the home office, Theo and Marianne were looking at the verdict form that all the lawyers had agreed to, and realizing that if then all the way to in certain directions, you ended up with an outcome that was not going to be supported by the law. And so as scary. The verdict form is going to the jury, I'm getting calls from Theo and Marianne saying, you need to take that back. And the judge was pissed. Like, he wanted a verdict form.
Yeah, of course.
And the other problem was, because the judge was waiting to make rulings on certain things, I couldn't argue the verdict form, because we're all taught that the best way to argue closing generally is to show them the verdict form. These are the questions you're going to be answering. And this is the evidence. When people are saying, no, it's yes, and this is why to answer this question. We could not use the verdict form for argument because the judge had not ruled on a couple of issues in the case. So it was a mess.
Wow.
And it was 13 pages, and it was.
Oh my gosh.
Yeah. So that's a long answer to your question. Generally, it is were they negligent? Was it a cause? That kind of simplicity. And sometimes you might have a premises claim, but you decide that you're not going to have all of the premises pieces, and you just go on a negligence side. So simpler, always better.
Yeah.
So back to you, how do you kind of winnow it down to
what to move on?
Yeah.
It's an art more than a science, of course. And a really important skill. And I tend to want to just go with one protective characteristic. I think it's very It's like a race plus or gender plus, where it was, they didn't discriminate against all the women, but only the Black woman. So it was a combination that she was both a woman and Black. So that's different. But when you're saying, oh, their motivation, because it has to be intentional, is because he took leave and he's over 40, and I think that dilutes all of the bases, really, if you don't have a good focus and good evidence. So I usually do one, but I've tried cases or a co-counsel, but that's one of the things I do as a solo to deal with workload, but I still work too much. But also try cases with people, which is also so great and fun, like other solos or small firms. And people disagree on this, so I tend to want to just stick with one, but some lawyers do want to go forward with two, because you might prove this and not prove that. But I worry about how attempting to prove both together, if it doesn't make a cohesive narrative, is going to affect the case overall. But it's very often because you need to plead it, because you don't have the evidence right in the beginning. So you're going to plead race and age and disability, and then realize it's really just a disability case. That's what was going on.
When you are narrowing it down, you describe it as an art. Do you use a jury consultant or a focus group to help you make decisions about what is likely to resonate, what isn't?
I haven't for that purpose, but it's a good idea. I think on that type of strategy, I've just leaned on the evidence. What's going to make the clearest story, and then, get rid of the rest. But, the one trial we had a lot of causes of action to begin with, the trial lawyer of the year that I keep talking about. But we ended up we dropped a lot of the claims, but they were really connected to what was happening to them. So there was one of our clients got shingles, and she was a very young woman in her 30s, the African-American lawyer, due to the stress. And so then there was a component that she wasn't accommodated, but so it kind of still fit the story. It wasn't just hey, they did this, and then, something completely unrelated.
Did you end up with an infectious disease expert for the shingles piece?
No.
Okay.
Maybe we should have.
No, I'm just curious because I had a case where a client developed shingles following a food exposure, and it was within 48 hours. And the carrier I had to find an infectious disease expert to write a report to support it. So, but
crazy.
Took the policy, so I'm okay with that.
Race has been such a theme in this conversation. What was interesting in this trial, we went to trial predominantly on race, discrimination, and retaliation. And the retaliation was for complaints of race discrimination. And that was a protected activity that they were retaliating against. We had a hung jury on the race claim. We brought race claims on behalf of both plaintiffs. At trial, we dropped the ones for the more experienced lawyer because the evidence was really that what happened to her was because she was complaining about race-based treatment that Ms. Bland experienced. The way you prove race claims is you draw inferences, because no one admits it anymore. It's not in an email. I mean, people admit it to people's faces, as you know. We don't hire women. Obviously, that's why we have these laws now, because there were literally no consequences.
Right.
And it was some of the best evidence of disparate treatment based on race that I've seen in any case in my whole career. And there was a hung jury on those claims. And it kind of goes back to this topic of race and the relationship that our societies have with race. And we talked to they gave that client $3.75 million in emotional distress damages, a huge award for, her having quit a job, and she's working again. I mean, she's not emotionally debilitated. Of course, all of her distress was real, but for the jury to get there was really remarkable. And so in talking to them about the race claims, they said we were equally divided, one of the jurors, and the people who didn't go for it just thought he's not a racist, which wasn't the standard. Right. We're not asking you to determine whether this person's a racist or not. Were his actions motivated by race, which is a different thing. And what it made me and my co-counsel realize, and my clients, is that's the complicated relationship we have with race. Is if this guy's a racist, is my dad a racist? Am I a racist? That's, what's happening subconsciously. If I have to, he didn't use the N-word, all these kind of subtle ways that and they were subtle and not subtle, mistreated her. I mean, really objective markers and comparison, they didn't all get there.
The question that comes to mind from that, you mentioned earlier in our conversation that one of the cases that you tried early on your own, you got a defense verdict, and it's one of the ones that you learned the most from. Is there a takeaway from that finding, the hung jury on the race piece in one of the most overt race cases that you've handled, in terms of ways that you might be able to approach this differently in the future?
Yeah, I think that's a really good question. And I think maybe we had to, and I hadn't thought about this. I just was like mad and let it go. But I should use it as a learning tool. I think maybe the way to do it is address it more directly, certainly in closing and maybe in opening this idea that that they, because they just thought, are we trying to determine whether he's racist? And that if these things were motivated by race, we've met the standard. And maybe you have to pander a little bit to say, this might not look like what you're used to in terms of what you think is, race-based behavior, because it wasn't extreme in the same way as the use of the N-word in cases or, awful things like hanging a noose over someone's desk. Those are all real life examples from cases. These more nuanced cases, which are really the cases that I try for whatever reason, they're the ones that come to me. I think the way to do it is, find a way to preempt that idea and maybe overtly say, we're not asking you to make any determinations about whether you think someone is a racist or not. It is about, that you've helped me reach that lesson. Maybe that's what we need to say. And it's bring them back to, of course we went over the standard with them, but maybe say that so they know that's not it, and then bring them back to the actual standard. Because it's difficult, because then it's like putting the mirror. I think it's complicated because, like you said, right, we all take actions that are, racist or sexist in some form because most people have some kind of privilege. So getting around that with a jury so that they're not internalizing it in a way is a challenge when it comes to something as sensitive, a topic as sensitive for some communities as race.
We talked a little bit about motions for summary judgment. Opposing summary judgment when you are a solo lawyer, I'm making presumptions, and again, I should ask, do you write all your own oppositions?
Yes.
How do you manage
Sorry, what a luxury to not write your opposition. Is that a thing? So you just hire people to do it for you?
I think different people do it different ways. I loved opposing summary judgment. And I find it's like doing a crossword puzzle. It
is. I wouldn't say I love it because of the workload, but yeah, when you're in it and you figured out how to beat it, it's exciting. Yeah.
The way I learned how to do it from Cynthia, Bilvine, others was deposition by deposition or depo summary by depo summary, and building the separate statement with factoids.
Yes, totally.
And I also would do it in a way where the factoids would tell a story.
Yes.
It wasn't just the facts that I needed to win, but what's the story that is compelling to the decision maker?
Yes. And, it's funny because the advantage, I've heard other employment lawyers say this too, the advantage of opposing summary judgment, though it's so much work, is that's when you actually learn the case. You don't really know the case because it forces you to get deep into the facts and factoids and then develop your story.
So you asked or said what a luxury to not oppose.
Yeah.
And one of the challenges I've found is I didn't have time to oppose summary judgment during the day. And so
yes, that's true.
Email, text, phone call, deposition, answer this question. And so when I was writing my own oppositions, it was, my workday would end.
Exactly.
And I would grab a bite to eat. And then from 7 p.m. till 2 a.m. was opposing summary judgment.
I didn't think about it that way, but you're absolutely right. Because you need focused, uninterrupted time. Yeah. But that's true. That's how it's always panned out for me. And I'm just a night person anyways. That's my best work, sadly, is when people are sleeping.
That worked for me until I had kids. And so I'm curious. And how old are your?
I have a 10-year-old daughter and a 6-year-old son.
Okay. And you're in a 2-lawyer household.
Yes.
How do you manage the night routine? And what I mean by night routine, my kids got up early in the morning, and so I had to learn to not be a night owl anymore.
Yeah.
When I would go to sleep at 2 in the morning and they'd be up at 5,
Ugh.
It didn't work.
Yeah, that's really early, by the way, 5. So your kids got up really early.
They got better. I mean, and now I could probably go back to whatever I wanted.
How old are they now?
10 and 11.
That's a good age, like, because they're out of the little kid stuff.
They're fantastic, and they do most of the things themselves, and so I can kind of I've learned to start letting go and going back to the way I lived before. But I've lost the night owl piece, and that was when I wrote because people didn't bother me.
Right. Some people do that on the morning end. Like I have colleagues and friends, I'm sure maybe that's what you do now. Like they get up at 4. They just normally get up at 4. And so they have that quiet at that time before the day starts. But that just will never be me because I'm not a morning person.
It sounds though like you've found ways to structure life as an effective parent and trial lawyer and opposer of summary judgment.
I'm a good parent. I know that. And I'm really bonded with my kids, but you worry, right? When you said the word effective parent, that didn't immediately resonate with me just because I think I'm self-critical of like, am I spending too much time away from them working? And I don't go far. I have an office, but I mostly work from home. I have a paralegal who works in the office, a wonderful person named Carolyn, who's such a huge part of the firm. But there's a lot of time I spend in front of my computer, even when my kids are around. So that's the reality of this work and having small children. For the most part, I think I'm an effective parent, but I'm not always a present parent.
I like that delineation.
Yeah.
I would say I'm a great parent, and my son would say that mom and dad talk about work all the time.
I can. It's also because you're the same firm, so you probably can't avoid it. Yeah, but I have. I do a lot, like at my kids' school, so I'm very conscious of making sure they see me in contexts that aren't just work. But I can't avoid the fact that they see me in front of my computer a lot because that's the reality of the nature of my work. So my partner's name is Chris. The way him and I make it work is, he's really not doing a lot of litigation anymore, and he works for the CPUC. He's one of their assistant general counsels, and he really made a choice as a parent to have a job where he has a big job and it's demanding, but I work off hours far more than he does, and so he made a conscious choice to be a more present parent. So I benefit from that in terms of having time to meet the demands of litigation. And Sheryl Sandberg famously said in Lean In, find an equal partner. I have an unequal partner in the respect that he does all the grocery shopping, all the cooking, all the dishes, all the lunch, all the food stuff, all the lunches. And so and puts our son to bed. My daughter's older now, and she and I, will hang out together, and it doesn't need as much. So there's a lot of stuff he is doing because of his choice in really a different. He was a litigator and a trial lawyer for the majority of his career.
That was when I think I first met him.
Yeah,
was it
exactly.
Carlson, Caledine, and Peterson. That's
right. Yeah. He was trained as a lawyer there. They're great trial lawyers, and then he did plaintiff side PI for years with some partners, and then his own firm, and then changed course. So that's how I'm able to do it. So that my kids are always with a parent. We don't have help that they're with, and with me a lot too. But it is a juggle, and it's a lot of thinking about and being conscious about how much time you are spending with them, what that time looks like, what they're seeing you do other than work. I mean, they're aware. I do have a lot of other interests. I don't have as much time as I want for those other interests, but I'm not a like one-dimensional kind of lawyer, which is important for them to see. So they have that. But if I had this talk with another lawyer recently, a woman I'm just not going to name her because maybe she doesn't want me to name her, but she's someone in our community, a wonderful lawyer, young mother as well, who said, I love what I do if it was just 30% less of it. And, that's the reality of the work we do, and especially solo practitioners or small firms, but certainly solos. A lot of work comes at you on a regular basis.
I will say, as you worry about whether the word is effective or present or what have you, as far as a parent is concerned, as we talk about sexism in the world in general, what a gift for your kids to see you as involved as you are. And I think of that as, you can either see it as I'm working too much, or you can see it as I have boy, girl who are recognizing that I have a parent who is an effective trial lawyer.
And thank you for saying that. And also loves what she does. So it's not motivated by money. Maybe it should be. Maybe I'd have more if it were. And it's, and I try to talk to them about the cases. And so, my son probably not, but my daughter's, for a while now, she's 10, so she knows, but since she was maybe 7 or 8, understands what discrimination means and discrimination in the workplace. So they know that it's work that gives meaning to, my days when they're at school. And so that part, yes, is great.
Makes me wonder what our kids will be talking about to their therapists when, and I'm only partially kidding, as my kids know what a prosthetist is.
I don't even know what that is.
It's a person who specializes in things for amputations.
Okay.
So yeah, we were outside of a grocery store one day, and my son was looking at, there was an individual who had obviously had an amputation. We had an amputation case in at the time, and he was making observations about the person's leg because he had heard things at the dinner table.
Oh my gosh.
In terms of what type of a prosthetic it was. Like, we're probably talking about work a little bit too much.
That is nuts and hilarious. But a very astute child. Learning multisyllabic words that are hard to remember.
Well, he's the engineer, so that is definitely more interesting to him.
That tracks. So he's going to figure out how to make things that assist that. Yeah.
I would be remiss if I didn't take us back a bit. You talked about workplace investigations, and I guess my uneducated takeaway would be, employer hires biased law firm to come in and build a narrative that supports the position that they did nothing wrong.
Exactly.
Okay.
I mean, that's the plaintiff employment lawyer's view. It's very rare that there's a finding. It's happened here or there where you've seen it. But usually they're wanting the employers hiring them to do a thorough investigation to tell them they didn't do anything wrong. And that, because they're under the law, there's a requirement not just when you receive a complaint, but if you have any notice of, discrimination as an example, or sexual harassment in the workplace, that you take prompt and remedial action. So how employers, meet that obligation is we commission an investigation immediately to look into it. They interviewed people, they collected evidence, and they reached this finding. So, we met that obligation.
And I'm going to pivot a bit to think of a lot of our listeners. You run a small business.
Right.
You are an employer.
Right.
A lot of people in our field are running small businesses.
Right.
So with that as a viewpoint, based on all of the knowledge, experience you've had, behavior you've seen, do you have any pointers for people who are running small businesses in terms of, how do I perform as the best employer I can and create both the best environment and also try to avoid getting sued?
Yeah. One thing to be aware of is not all laws, employment laws apply to small firms. So you need at least 5 employees for the Fair Employment and Housing Act to apply for discrimination. So you can't be sued for discrimination if you have less than 5 employees. You only need 1 employee to be sued for harassment, though. So, all the laws might not apply to, these leave laws, the CFRA, California Family Rights Act, or FMLA is the federal counterpart, don't apply to small firms, though the number is getting smaller and smaller of who they apply to. I don't know, on one level, the answer is know the laws, obviously, and there are laws that apply, to the municipal area, and then California. I mean, as you probably know, California has the most employee-friendly laws in the country, but then there's other rights you have under San Francisco's laws, right? So one obvious thing is to be knowledgeable, but I think the other thing is just treat people with respect, as simple as it sounds. That will allow for avoiding legal disputes, I think, more than anything, and be open to understanding that you might have made a mistake, even legally, and taking a remedy. Then there's really no case. If you really take an immediate remedy for something you did wrong, there's no damages. What's the case, right? And so if you treat people with respect and listen and have an open mind to having maybe done something wrong and take remedial steps, you're going to protect yourself. And the respect piece is because then there's ways you can work it out with someone rather than having it go into a legal claim.
That all makes sense. Well, being a jerk is not actionable. Don't be a jerk.
Yeah, exactly. Yeah, it's like, it's a little bit contradictory. Like, you can be a jerk under the law, but if you're not a jerk, you're going to protect yourself more under the law. Yeah.
That makes sense. Well, I've really enjoyed our conversation. Thank you for taking the time.
Me too. Thank you so much.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions on ways in which you have handled employment cases. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.